New firmware of it is available. Good news.
Wait. Wasn't all that fast.
No.
Yeah.
That would be the time.
Yeah, we can, yeah,
Yes.
we can hear now, guys.
Yeah.
All right, are we on the grant application for Nueces County?
I don't know if they can hear us.
Basic speakers in the computer. I think that may be what we
Yeah.
have to do.
I don't think they can hear us.
I don't either.
Hi, Judge. We can hear you now. We just
Oh, you
clicked-
can? Okay. Are we on the grant application for Nueces County?
We're still working on the technical difficulties.
Oh, okay.
We're about to take up Nueces.
Yeah. We could just turn the computer sideways.
I think they might.
Okay.
We could just be.
Okay. It's back. I'm just gonna.
Judge Keller, can you hear us okay?
I can hear you, yes.
Okay, we can hear you. It's not very loud, but we can hear you okay.
Yeah.
Judge, would you like us to go ahead and proceed just with what we've got so far?
Let's do.
Judge Maderi, if it's okay, then I'm turning to Nueces County. So members, if you can look at page 27, or I'm sorry, 26 of your meeting book. This is a request from Nueces County regarding their 2 indigent defense coordinators. This is, I want to make sure that we own this on the staff side. This is really just a mistake on our part on the staff side as far as the calculation. We already, the board already approved this back in June, but there was a discrepancy, a mistake of about $1,600 mathematical error. So we're just bringing that back to you for your attention. We apologize for that mistake, but the recommendation on the staff side is to increase the Nueces County FY 22-23 continuing grant award for the Indigent Defense Coordinator team by $1,660 for a total of $69,952. Happy to take any questions.
Thank you, Jeff. Is there a motion to increase Nueces County's FY 2023 continuing grant award for the Indigent Defense Coordinator team by $1,660 to $69,952?
Forrest.
And we're gonna, okay. I couldn't tell if there was a motion and a second. Was there a
Judge,
second?
there was a motion by Judge Evans and a second by Mr. Bunnan.
Any discussion? All in favor?
Aye.
Aye. Any opposed? Motion carries. Thank you.
Yeah, Judge Keller, can you all mark me down as abstaining from Nueces County vote, please?
Yes, thank you, Judge.
Thank you.
Thank you, Judge Keller. Thank you, Judge Maderi. Turning to page 27, we have Hayes County. So this is a MyPedea program. If you all recall, gosh, I guess about 3 years ago now, we piloted a project to ensure that, and this was in Judge Stubblefield's administrative judicial region, to make sure that all defense attorneys in the region had access to a Padilla advisal from a Padilla attorney. The program went very well, and we've basically taken it statewide. Usage has consistently gone up quarter by quarter, though it's still lower than we wanted. But it is enough to basically take up the time of a full-time employee at this point. So we're recommending continuation of that program. Again, this is, I think this has been a big success for TIDC. That we have, again, I don't think we have any defense attorney in Texas now who can say, I don't have access to a Padilla advisal because of this program. So we're really grateful for Capital Area Private Defender Service for taking this on. So the recommendation on the staff side is to increase Hayes County's FY 22 improvement grant supporting the statewide remote Padilla compliance program by $136,451 to continue the program operations through FY 22-23, contingent upon receipt of a signed request from the Hayes County judge. This is the only thing, just one note, we are waiting for that resolution from the county judge, but we're told that it is on its way. I'm happy to take any questions.
Thank you, Jeff. Is there a motion to increase Hayes County's FY 2022 improvement grant supporting the statewide remote Padilla compliance program by $136,451 to continue program operations through FY 2023, contingent upon receipt of a signed request from the Hayes County judge?
So moved. That was fun.
Thank you. Is there a second?
I'll second Vivian Torres.
Here we go.
Did I miss out?
No.
Good, got it.
Any discussion?
Yes, ma'am.
Yes, sir.
What is the increase to?
So do you want, we actually have a private vendor service. Do you want to talk about that, Bradley?
Sure, absolutely. Thank you, Jeff. Can everyone hear me okay? Online. So the increase really just extends the duration. This is an unusual grant because it's kind of been extended over more than one fiscal period because it didn't meet up originally. So the extension just funds it through the full fiscal period to line this up with your renewal process. So the current funding was only going to carry us through a tiny portion of the next fiscal year. This closes that gap and lines up what was a out-of-sync grant to coincide with all the fiscal years. So the spending will continue to be what it has been over the last 6 or 8 months since CAPS took over the program and stabilized. I don't want to say stabilized, it was doing quite well, but took it over, made it a full-time FTE, and have been running it during that period.
So there's no increase, it's just extending the time.
Really, that's it, yes, because it's not increasing the month-over-month cost of the program at this time. It's really just continuing. I mean, there may be a slight, the budget may have a slight increase over, but what Edwin and I did is looked at what our expenses were over the last 6 months and confirmed that matched our budget. And so while it may not be to the penny, it's not a substantial increase in cost over what we have been, or what TID has been funding for this grant.
Okay, thanks.
Any other questions? Any discussion? All in favor?
Aye.
Aye. Any opposed? Okay, I couldn't hear if there were, what the vote sounded like. I heard some ayes and I didn't hear any nays. So did the motion carry?
Yes, Judge, I believe it was unanimous.
Okay, thank you.
Thank you, Judge. Moving to page 29, this is Tom Green County. This is a 7-county rural regional public defender office anchored in San Angelo. As I mentioned before, with like the Far West Texas Public Defender Office, this is a request really just to try to keep up with inflation a little bit. There is an increase across the board for staff of Tom Green, or employees of Tom Green County. And this is really just trying to keep pace with that Tom Green County increase. Most of the salary increase they were able to absorb from other line items within their budget, but there is a small additional cost in order to keep up with Tom Green, and that cost is a total of $4,829. The recommendation from staff is to approve recommended budget above to accommodate countywide salary increases and to increase Tom Green County's FY23 sustainability grant by $4,829 to a total of $1,235,058. Judge, there's one other note I would mention. Tom Green County had a second request related to this. That second request is for an additional FTE who would be devoted to discovery and going through legal discovery and working, so it'd be a non-attorney position and working with the attorneys to support them through discovery. Our recommendation on the staff side, and we have talked to the chief public defender there, is that we should leave that pending for a couple different reasons. One, TIDC has not funded a position like that before, so I think it requires a little bit more research and whether this would affect additional, if we funded it here, if it would affect other rural regional public defender offices. Two, the office has not been taking cases for very long. They've been around for just about 3 or 4 months when it comes to taking cases. So we think it's a little bit early to make that move. So we would not recommend voting in favor of that, but we do again recommend a $4,829 increase. And of course, I'm happy to take any questions that the board might have.
Okay, thank you. Is there a motion to approve the recommended budget in the meeting book to accommodate countywide salary increases and increase Tom Green County's FY23 sustainability grant by $4,829 to $1,235,058?
So moved, Alex Klein.
Your second?
Kevin, second.
Any discussion? All in favor? Aye.
Aye.
Any opposed? Okay, motion carries. Thank you.
Thank you, Judge. And this is the last motion, or sorry, the last grant that we, or modification or supplement we have up today, which is page 32. This is Galveston County. A reminder, the Galveston County is a mental health public defender office that TIDC helped establish. They had submitted a request to really try to keep up with the DA's office in terms of salary parity. However, the DA's salaries are not fixed just yet. It's still kind of in flux. So we did talk to the chief public defender, and right now we don't think there's any need for a motion. I think this is something that the board could revisit in December, but I'm happy to take any questions that you might have.
Okay, thanks, Jeff.
So I would, when we postpone the action,
That's correct. Yeah, our recommendation is to postpone action.
that's my motion.
Okay. Judge, we have a motion from Judge Evans to postpone action on this.
Okay, is there a second? I can't hear. Everybody check me.
All right, second.
We have a second by Mr. Brennan.
Any discussion? All in favor? Aye.
Aye.
Any opposed? That motion carries. Thank you.
Thank you, Judge. That takes us through all the improvement grants. And that brings us to consideration of the proposed FY23 budget. Sharon.
Yes. So on page 33, you have the FY23 proposed budget. And at the top, you see we have, and I just want to keep you in mind that this total amount, 69 million point 7, is the amount that also was our request in the LAR. So we're going to have our regular appropriated funds of 43.8 million. We also have UB from the Operation Lone Star, which was Fund 001 that came in 22. This is the amount that's going over into 23. And then we also have the 10 million that I talked about earlier in 22 that we're going to UB over into 23. So this is the 10.3 for that. And then we also have a request in for a CJD grant from the governor's office of $184,912. So a total this year for 2023, we are looking 69.7 million for our revenue. And then below you see the budgets. We have the formula grant, 20.5 million. We have our competitive improvement grants of 10.8. We have a sustainability grants, which are 13.9 million. You see down, we also have extraordinary, we have a mental health, which is 938,103. We also have money set aside for extraordinary and technical support grants, 200,000 each. We have the Operation Lone Star, which is the House Bill 9, 15.7, which is the same as the UB amount we are carrying over from 23. And then we have our administrative costs for both Fund 5073 of 1.9 million and also Fund General Revenue Fund of 201,000. We have a PPRI contract of 194,200, and then we also have a contract with University of Texas for our interns. And then we have other expenses, other contracts. We have our Innocence Project rider, which is 600,000. Of course, the CJD grant, and then also the administrative support that we pay OCA, which is 114,000, for a total of 65.7 million for our budget. So we're looking at right now, we have 3.9 million and close to 4 million that we have is not budgeted as of now. So this is our budget for FY 2023.
Thank you, Sharon. And Judge Keller, we have a motion.
Okay, I don't have a list of motions, but is there a motion to adopt the proposed 2023 budget? Is that what we're talking about?
That's correct, Judge.
Okay, is there a motion?
So moved. Alex
Is there a
Bud.
second?
Yeah, budget.
Is there a second?
Allison Michael, second. Evans, I'll second it.
Okay, any discussion? All in favor? Aye. Any
Aye.
opposed? Okay, motion carries. Thank you.
Thank you, Judge. And then we can turn to issuance of the FY23 formula grant request for applications, and that is Doriana.
Thank you, Jeff. If we go to page 34 of our meeting notebook, so I can go over the formula grant request for applications and budget. So each year, the TIDC TIDC issues the formula request for application, the RFA. And the draft RFA for FY23 has been updated with new dates and no substantive changes have been made. We included how formula grants are calculated on this page, and the full draft is available in the link in your meeting notebook. The recommendation is to adopt the FY23 formula grant program budget of $20.5 million and to issue the FY23 formula grant program request for applications. And if there aren't any questions, we have motion number 10 to direct staff to publish the FY23 formula grant request for applications.
Is there a motion to request that staff publish I don't have a list of motions in front of me.
I'm happy to read it. The
Okay, would you
motion,
please?
is there a motion to direct staff to publish the FY23 formula grant request for applications?
Is there a motion?
So moved, Vivian Torres.
Is there a second?
And then Alex Bonin just seconded.
Any discussion?
I have a question. The amount budgeted for formula grants is exactly the same as last year.
That's
Correct.
exactly,
No change at all.
that's correct.
Should be-
Any further discussion? All in favor? Aye. Any opposed? Motion carries.
Wonderful. On our next page, we have the updated Indigent Defense Expenditure Report Manual. Again, every year, county auditors and treasurers must file the IDER, which details case counts and expenditures. Staff has updated this year's IDER manual to provide guidance to the auditors and treasurers. Draft changes for the FY22 IDER are non-substantive and reflect no new policy changes. They include updated dates, addition of technical definitions to the glossary related to CPS reporting, and minor edits for clarity. The draft IDER may be reviewed in its entirety in the link in your meeting materials. And if there aren't any questions, we have motion number 11, and I'm happy to read that for you, Judge.
Would you read it, please?
Sure. Is there a motion to direct staff to issue the FY22 Indigent Defense Expenditure Report Manual?
So moved.
Moved by Alex Lennon,
Is there a second?
Second.
seconded by Judge Evans.
Any discussion? All in favor?
Aye. Aye.
Okay, motion carries. Thank you.
And on our next page, we have the Texas Administrative Code Grant Rules Update. TIDC's rules are found in Chapter 173 of the Texas Administrative Code, and every state agency is required to review and consider for readoption each of its rules every 4 years. The proposed rules must be published to the Texas Register for public comment before they are eligible for adoption. And staff has reviewed the TAC grant rules and proposed the updates that follow in our meeting materials on the next few pages. The bottom set of bullet points details the proposed changes. And the staff recommendation is to publish the draft grant rules revisions in the Texas Register for public comment as presented in the meeting book with the following changes from yesterday. On page 45, in 173.304, replace shall be required with must. And on page 49 of our meeting materials, under item K, strike or the grants and reporting committee from the proposed sentence, from the proposed new sentence. And if there aren't any questions, we have motion number 12, which I'm happy to read.
There was one more change, and it was changing the word may to, wait, did you say change the word may to must?
It was page 45, and it was to change shall be required to must.
There was another one. There was another change that I think was on page 39 or 40.
Judge,
Where-
page 40, I believe it is, and this is in 137.104, and I apologize, I just now caught that, I had a note on that. This is page 40, 137.104.3, where it reads designation of the financial officer for the grant to, and right now it says may, and I believe, Judge, the change was from may to must, as you were mentioning.
Right. Okay, with those changes, what does the motion say, Doriana?
Okay, is there a motion to publish in the Texas Register for public comment and rule review in the updated grant administrative rules in Texas Administrative Code Title I, Part 8, Chapter 173?
Is there a motion? Is there a second?
Second. Vivian seconded. Judge Torres, second.
Was there a second?
I'll second it.
Okay, any discussion? All in favor?
Aye.
Aye. Any opposed? All right, the motion carries. Thank you.
I believe up next we have Deborah Stewart.
Okay. Good morning, everyone. The fiscal monitoring report begins on page 51 of your meeting. I put several pages here, and I've got everything listed for the fiscal year. I just kind of want to.
Deborah, can I interject real quick? Judge Keller, can you hear Deborah okay, or would you like her to move over to closer to the speaker?
I can hear her okay. It's not loud, but I can hear her. Thank you.
Okay, great, thank you. Sorry about that, Deborah.
Sorry, I'll see if I can speak. So anyway, turn to page 51, and I've got monitoring activities listed there, and this is for the fiscal year, and which we've got the end coming up here in a couple weeks. But anyway, just to summarize the activity just since June, I've been issued 2 initial reports. Those were to Kenny County and Karnes County. I issued 1 final report that was to Taylor County. I did get the response from Karnes County this week, so I expect that final report will be issued next week. They have several reviews still open, but we're working to get those resolved, and they're all at various stages of the process. Additionally, since the last meeting, I had 3 counties submit their comprehensive annual financial reports and single audits. Those were El Paso, Tarrant, and Matagorda counties. And so for El Paso and Tarrant counties, they each had their TIDC grants selected for review on the single audit, and neither one of them had any compliance issues. And that's all I really have. If anybody has any questions?
Okay, thank you. Where are we, Jeff?
Judge, that brings us to the policies and standards section of the meeting.
Okay, thank you, Judge Maderi. Mr. Bundin, I believe you're up.
Okay, I'm going to ask Wesley to give us a summary of what we did last week.
Thanks, Mr. Bunnan. On page 57 of your meeting notebook, there's a summary of the Policies and Standards Committee meeting. That group met, all 3 members attended. That was on August 9th. And there were 3 main things that were covered. One was follow up on Maverick and Zavala County monitoring reports. Mr. Lawrence reported that we have received a response from Zavala County, and they have a very viable plan to meet all of the non-compliance issues that we found. In the meantime, Maverick County requested an extension of 60 days, which is permitted by the rules. So that's now going to be due August 26th, so next week. He also reported that in these sorts of situations where we have long-standing non-compliance findings that haven't been resolved, we've in the past asked for interim reporting of some data to see how their new systems are actually going to come into compliance rather than waiting a year or 2 to go back. So at that time, the committee directed staff to require those 2 counties, Maverick and Zavala, to provide monthly reporting of data elements to basically see how the compliance is being maintained. We also considered legislative proposals at the committee meeting. There were 5 new and 7 previously adopted proposals, and we'll be turning to those in just a minute. But two of those were don't have a committee motion. 3 of the new proposals do have a committee motion to adopt, and then the 7 prior proposals have a committee motion to adopt as well to the full board. So we'll take those up in just a second. And then the last thing is we, at the direction of the committee from the June meeting, did some additional research. Kristen Meeks made a report on some national data on determining indigence, basically to supplement what the Deason Center had presented in their report in June about standards used around the state. And we'll be bringing a selection of recommendations or options back to the committee at their next meeting prior to the December board meeting.
Okay, so we need to go to the legislative proposals. Can you briefly explain? So
Sure.
the first legislative proposal, I believe, it was just voted on by Judge Keller and I. We did not have all 3 members there. And
That's right, the first 2 actually.
the first 2.
Yeah.
And how did you want to explain how the votes went on that?
Sure, so we decided to bring those two back to the full board without a committee recommendation.
Right.
There was a vote for and against, and all the other ones had a vote for.
Okay.
I was gonna just lay out the
Yeah,
history
just
very
lay-
briefly
Sure.
of the since this group met, the full board met, we've had 2 work group meetings, legislative work groups, and you've got your members listed on page 58 and 59 of the group. There was a lot of work between those 2 meetings on particular recommendations. And the only other thing I'd say is that beginning on page 60 is your legislative policy with revisions that were adopted by the board in June. And the only really relevant one for today that's important is for a proposal to be advanced, it requires 2/3 of the members present, and that's 5 today out of 7. So in case that's an issue. And then we can turn to the proposals if you like, Mr. Bowman.
Okay, can you lay it out?
Sure. Well, actually, Olivia's going to lay out proposal 1.
Okay,
We're going to
great.
tag team between me, Scott, and Olivia. Actually,
Great.
So.
Awesome. So on page 65, we have the first proposal, and it was proposed by Ted Wood at the Harris County Public Defender Office, and it would amend Article 26.05 of the Code of Criminal Procedure to prohibit plea bargains requiring defendants to pay for their court-appointed attorneys without court approval. So in many counties, indigent defendants who plead guilty are required to pay for the cost of their court-appointed attorney. However, they should only be required to do this if there was a judicial finding that they have the ability to pay. So this would basically make that requirement more clear. This proposal has had 3 different versions that have been developed over the summer, and it was approved by the Ledge Work Group, but as was just mentioned, there was no motion by the PNS committee earlier. So this is the second time this proposal has been brought, and it was not approved back in 2018. And this time around, people at the work group had similar concerns as to the first time, which would be that it could potentially limit the discretion of parties and prevent pleas from happening. So to address those concerns, the second draft of the proposal was worked on by a subgroup, and it would have made 26.05G not waivable. And many originally agreed this was a good idea, but then feedback from the second work group led to this updated version that's in your meeting book, because there were concerns about not letting the defendant waive if he or she wanted to, and that this could potentially be overreach, and was a problem of judicial failure if there was no finding of the defendant being able to pay. So because of this, the more specific language was added to the third proposal to put the onus back on the judge, saying the ability to pay would need to be found regardless of an agreement between the defendant and the state. So this proposal was approved by the Ledge Work Group, not by the PNS committee, and we are here if you have any questions.
Okay, and just to get, I remember part of the discussion was, I wasn't sure, Jim Allison's here, and I know we didn't, I don't know if we got an opinion from you about the final language, because you were present at some of those groups. I guess I wanted to hear what you felt about it.
Thank you, Alex. There's Jim Allison, General Counsel, County Judges Commissioners Association of Texas. We did, as been reflected, work on this proposal and reached, I think, closer to consensus, but not quite. Our concern in the revised proposal found in your materials for today's meeting concerns the phrase notwithstanding any agreement between the defendant and the state. We have no problem with the other language in the proposal to make this a part of the inquiry required under Article 42.15, and we have no problem with adding the only in there for emphasis. But the language notwithstanding any agreement between the defendant and the state appears to us to be a bit of an overreach and unnecessary. The court, of course, is not bound by negotiated plea agreements, but in normal procedure, as I recall, if the court's not going to follow a negotiated plea agreement, the court informs both parties, the state and the defendant, and they have an opportunity to withdraw from the plea agreement and proceed to trial. This language seems to supersede that and would allow the court on its own, without allowing that option, to make a finding different than the plea agreement. And while we think of that as a way that the court could reduce a plea agreement to pay the costs of the appointed counsel, it could in fact lead to the court determining that the defendant could pay more than the plea agreement, and enter a finding to pay more without regard to a plea agreement. I think it'd be best to just leave that language out. That would maintain the current practice of we're not going to follow a plea agreement to notify the parties, but it still leaves entirely the burden on the court to determine whether the amount the defendant can pay and to order only that amount. I think that meets the need without interfering with plea negotiations. So for those reasons, we'd request that if we're going to advance this as a legislative proposal, that we simply take out the language about notwithstanding any agreement and go forward with the remaining language. Be happy to answer any questions about our concerns.
Okay. So I guess first, we have to see if there's a motion as written. There'll be a motion in favor of it as written. Would there be, if not, I guess I can ask, would there be a motion in favor as amended, as suggested by Jim Allison's changes?
I'll make that motion.
Okay, so we have a motion. Can I second motions on this chair?
I'll second the motion.
Okay, all right. So we're gonna have to, can you make it so that we know what's the amended language?
Yes.
Okay.
Yep, so the motion is to approve proposal number 1 with the amendments suggested by Jim Allison, which is the removal of the clause notwithstanding any agreement between the defendant and the state.
Okay.
Because basically, you're renegotiating the plea the way it is.
Yeah, I think the main impetus for doing this is to make sure judges don't forget their obligation to make that finding just simply because it's in a plea agreement. Otherwise a clerk will just look at it and go, okay, we can just go and put those numbers in because it's in the plea agreement. So I think that would satisfy the overall effect of it, and I'm for it. So we have motion second, all in favor?
Wait a minute, we forgot discussion.
Yes.
We forgot discussion. I'm not sure this is necessary.
Yeah.
And I hate to make a legislative proposal that is not necessary. I don't think it is.
I thought it was already required, quite honestly, but if clarification is needed, I'm not opposed, but I really think it is redundant because we already do it.
Well, the point I was making is I don't think it's clear when there are plea agreements. If you put them in plea agreements, I think there needs to be an emphasis that this finding still has to be made. Because people are going to put them in plea agreements, so it needs to be clearer, and I think that's the point of it. So it is something in addition, yes. Okay, so with that discussion, all in favor?
Aye.
So we have to count that, I guess. 1, 2, who else? Judge Torres, you're aye?
Yes.
And
Collier's aye.
oh, yes, Chair. Okay, so do we have 5?
Right.
It's 4. How many? Okay.
We haven't heard from Judge Maderi, I believe.
Yeah, I'm on. I'm voting against it. I don't think it needs to be cleared up, but I mean, I'll do whatever the will of the committee is.
All right. So right now, so we're missing a vote?
Yes, Representative Smith.
Okay, so let's Representative Smith, just so we'll know.
Wait a minute, I can't.
That's a good vote.
Oh, no, stop it.
Roll?
Yes, let's take roll.
All right, let's do that.
Where are we? Are you calling for a no vote? I'm no.
Take a roll. We're going to take roll.
We're going to take roll. Okay, the Honorable Sharon Keller. I believe she was.
No.
Got it. Mr. Alex Bunnan,
Yes.
the Honorable Valerie Covey, the Honorable Brandon Creighton, the Honorable Richard Evans,
Aye.
Mr. Gonzalo Rios, the Honorable Nathan Hecht, the Honorable Missy Maderi,
No.
the Honorable Nicole Collier,
Aye.
the Honorable Reggie Smith. You're on mute, Representative.
Representative Smith, I think you're on mute.
Yeah, I think you're on mute, Representative Smith.
Oh, apologize for that. Respectfully, no.
Got it, thank you. The Honorable Sherry Raddick, the Honorable Vivian Torres,
Yes.
and the Honorable John Whitmire, excuse me.
Yeah.
And that is it.
It doesn't pass. yeah.
Okay,
Yeah.
so
All right.
it does not pass.
Does not pass.
Okay, so now we go to 2, which is also not a committee motion. It is
That's right, it's Scott.
Scott.
Can you read this one?
This is mine. So proposal number 2 is begins on page 68. This proposal comes out of observations that TIDC staff has made during policy monitoring visits. We have observed some counties where unrepresented misdemeanor defendants are pleading guilty without first being advised of their right to counsel and being given an opportunity to request counsel. This proposal originally was much larger and made a number of changes to the waiver statute, but those provisions were removed, and now it is limited to requiring a judicial advisal about the right to counsel at arraignment or that first appearance before a guilty plea or a no contest plea is taken. The language.
I'm sorry, excuse me. I hate to interrupt. Can I get you to summarize that one more time for me? I apologize.
Sure.
But I want to make sure I give it due consideration.
Absolutely. So this proposal, it comes out of observations that TIDC staff has made during policy monitoring. We have observed some counties where unrepresented misdemeanor defendants are pleading guilty without first being advised of their right to counsel and being given the opportunity to request counsel. This proposal was much larger when it started off, and it made changes to the waiver statute originally, but we removed those provisions, and now it is limited to requiring the judge to advise the defendant about the right to counsel before a guilty plea or a no contest plea is taken.
Thank you.
The language for the proposal is on page 69 of the board book.
Judge Evans has a question?
The prosecutor's not even supposed to talk to the defendant without a waiver.
That's right. Yeah, this is already there, isn't it?
It's there. If they're doing it, some judge is in trouble.
We have observed it. We have made policy monitoring findings. There's nothing clearly in the arraignment statute that clearly tells the judge that they need to be advising the client or the defendant, before a plea is taken. Originally, also, I guess this language was slightly changed at the request of Jim Allison. Originally, it just said before a plea is taken, and Jim suggested that it be changed to a guilty plea or a plea of no contest, that it be the advisal occur. It only applies to defendants who are not represented at arraignment or that first appearance.
They can negotiate the plea before you ever advise them. They're right.
If they requested counsel at magistration, the prosecutor should not be talking to that defendant if they requested counsel prior to arraignment. Correct, Joel?
My understanding was that the prosecutor could not talk to them until they waived counsel, period. Am I wrong on that?
No, you're right
Well-
on that. That is the way that I've seen it done, and I thought it was required. The prosecutors won't even confer unless they get a waiver of counsel in writing, and the court has admonished the defendant.
Well, I guess I can also say in one of the observations that I made in one of the counties, there was no conversation had occurred between the prosecutor and the defendant before they were making a plea in open court, but the defendant was also not advised that they had a right to counsel or given an opportunity to request counsel, except for it. Basically, they pled guilty. There was the plea paperwork, which is lengthy. Don't know if the defendant really understood what was in the plea paperwork, whether or not they could read or not. So there was no conversation, and I confirmed this, there was no communication between the prosecutor and the defendant before that defendant pled. However, they pled in open court. And then after they pled, they were given some paperwork. They were not advised of their right except for in the plea paperwork.
Never done anything like that. That's not your county.
Yeah.
Right.
I mean, I'm trying to understand how it would work. You're taking a plea without the prosecutor being involved.
Yeah. How is there even a plea bargain? But I have a problem with proposing legislation based on some individual court not following what they're supposed to follow. I mean, the solution for that is to take appropriate action, either by the avenues that are available, including grievances to the Judicial Commission, if that's the case, but not to legislate. It's like legislating on anecdotal evidence. I don't like it, based on the experience of one party, one person.
Chair Collier, did you have something you were going to say?
Yes, I was trying to find the button. I'm so sorry. To raise my hand, I was like, which one is it? I apologize. I did some tours of various counties, and I got the chance to see some really great public defender offices. And one of the complaints that I continue to hear is that there is this problem where they are not told that they are entitled to an attorney. So there's some negotiating going on before they even, know the full breadth or extent of their rights or what they can ask for. So they end up taking a plea, not knowing that there's other options, because people want to get back to work. They want to quickly, get back to their normal life. And even some people, take the plea if they're innocent or they're not, they're not guilty. So I do believe that there needs to be clarity in the law that this proposal could provide.
Jim Allison has a comment.
Thank you, Jim Allison, General Counsel, County Judge and Commissioner Association of Texas. We expressed concerns about this one because it appears to be an overkill. It would apply anytime a defendant was not represented by an attorney or at their first appearance, either at arraignment or their first appearance. And as has been pointed out, these warnings should have already been given, either at time of arrest with the Miranda warning or at the time of magistration in the 15 or 17 hearing. So, but yet this would have it repeated for every defendant who's not represented by counsel. So we agree that we think this is already covered. We think the prosecutors are already under the requirement to make sure that if counsel has been requested, that it's been ruled on before they communicate with the defendant. And as I think has been indicated, when anyone enters a guilty plea or no contest plea, they are executing a written waiver of counsel. This would seem to be adding one more layer that's already covered if the court and the prosecutors are doing their job properly now. If they're not, then of course, attention needs to be paid to those prosecutors and judges. but it does seem to be a lot to add this layer to every defendant who appears in these cases, even if they've already had the warnings. This is going to require to get them again. So for those reasons, we agree. We don't think this one is needed and would be a perhaps better administration of the rules we have now might be called for. Thank you.
Thank you, Jim. Okay, any other comments?
This is Nicole.
Sure.
I certainly hear you and appreciate your response. Absolutely, I agree that this should already be taking place. But the great research that the TIDC team has done has shown that the actual appointment rate is not what it could be or should be, considering the number of arrests and the types of cases. So that raises the alarm to me that we're missing some people. We're missing the goal of making sure that we meet our constitutional obligation of providing an attorney for those who are in need. So just the sheer number of people who don't have an attorney at the time that these agreements are made raises concern, and it should be for everyone. And it warrants further investigation. And this is what the staff has recommended to do, is to ensure, because if you think about some people, I don't know how much time passes, from the time of the arrest and then arraignment, especially for those who have been taken in custody under the Operation Lone Star. There could be multiple days, even, I guess, before you get before these types of hearings. So a repeat is not knocking the judge. It's just ensuring the process. We're preserving the process and integrity of that process by just reminding somebody.
I guess that's I thank you for that, Chair Collier. I was going to make a similar point that it can be weeks or months between magistration and arraignment or that first appearance. During that time, we see time and again that requests for counsel are not ruled upon in counties. They may have forgotten. They may have said, I can hire a lawyer at magistration, and then by the time arraignment or that first appearance comes around, they haven't hired a lawyer, maybe they can't afford a lawyer. And I think the purpose here is just to ensure that defendant knows they have a right to counsel and they're given an opportunity to request counsel before they make a guilty plea.
Chair Collier, would you be willing to make the motion for this item?
Sure, so moved.
Okay. I'll second it. I think we're gonna have a split vote. Can we take a roll call?
Sure.
Because it's too confusing to do it.
All right. Okay, I'm gonna take roll. The Honorable Sharon Keller,
No.
Mr. Alex Bunnan,
Yes?
the Honorable Valerie Covey, the Honorable Brendan Creighton, the Honorable Richard Evans,
No.
Mr. Gonzalo Rios, the Honorable Nathan Heck, the Honorable Missy Maderi,
Yes.
the Honorable Nicole Collier,
Yes.
the Honorable Reggie Smith,
Yes.
the Honorable Sherry Raddick, the Honorable Vivian Torres,
No.
and the Honorable John Whitmire. That is
4 in favor, right?
4 in favor.
That's not sufficient, right? Okay, so it does not move. Okay, so now number 3. This was a committee motion.
Yes. So it's on page 71 of your meeting book. Proposal 3 was brought by Jim Bethke at the Bexar County MAC, and it would add language to section 411.082 of the Government Code to give managed assigned counsel programs free access to DPS's criminal history information. So back in 2013, there was a bill that was not approved at TIDC, but was achieved by finding another sponsor that gave Public Defender Office and the Office of Capital and Forensic Risks free access to this criminal history information. So this would just be bringing the managed sign councils in on that as well. And there was no objections at either work group, and there were some questions on how implementation would work, and those were addressed. And it was approved by PNS, so there was consensus, and Jim Bethy's here if you have any questions, and so are we.
Okay, so as a committee motion, we don't need, we don't need a second or anything, okay.
That's correct.
So is there any discussion? All in favor?
Aye.
Aye.
Anyone opposed?
Aye.
Okay, I think that was in favor. All right, so unanimous, passed. Okay, good. All right, next one.
So proposal number 4 begins on page 73. This proposal clarifies the duties of managed assigned council programs. It clearly authorizes MACs to have oversight boards, and it authorizes MACs to appoint counsel in death penalty cases if the judges in a county authorize the MAC to do so. Many of the provisions here were previously approved by TIDC's board before the last legislative session and was introduced in HB 2608. All of the provisions here were vetted by directors of the MAC programs here in Texas. If you look at the text, black text are the proposals that y'all previously approved last session, and then red text is new provisions in this proposal. And if it's underlined, that's new language. If it's not underlined, that's existing law language. This was approved by PNS. I can go through each of the different sections if you would like.
Well, is there any discussion on this item or questions for Scott? I think you're good. So, all in favor?
Aye.
Aye.
Okay, so it passes. Any opposed? I'm sorry. It passed. Okay, next item.
Thanks, Mr. Bunnan. Turn to page 80. This is proposal 5. This is the last of the new proposals for this session. And this would allow counties to be reimbursed for representation provided by a public defender's office in the county when the office of State Counsel for Offenders cannot provide representation for an indigent inmate in prison. So under current law, and it's been around for a long time, there's a provision for where the State Counsel for Offenders cannot represent somebody, usually due to a conflict of interest, multiple co-defendants, that the county or the court that where the case is has to appoint local counsel. And the statute envisions private counsel. Of course, when it was written, there weren't public defender offices generally, and certainly none where there were prisons. In the meantime, the Texas Rio Grande Legal Aid has been providing representation. They've been appointed by the local court in B County to provide representation in about 30 or 40 cases a year to indigent prison inmates. And the issue is that under current statute, they aren't permitted to seek reimbursement, or at least it's not clear that they can seek reimbursement for the cost of that representation. So essentially, this proposal would allow the public defender to certify to the court the amount of expenses incurred in that representation, and for the court to submit that to the controller for reimbursement to the county. And this had no opposition at the work group nor the committee. It was adopted by a committee motion.
Okay, any questions or discussion? All in favor?
Aye. Aye.
Aye.
Any opposed? It's unanimous.
So there were 7 proposals that were adopted by the board 2 years ago that did not pass the legislature. There was no known opposition to them, but as you know, only about 15% of bills passed, and so these did not. Because in my looking around the room of who's in attendance, I believe all of you were here 2 years ago when these were approved by the board. So my proposal is to go through them very quickly, just hit the headlines. What do you think?
I would,
Maybe
well,
not even?
I would just ask if there is
Yeah,
any of these
concerns?
items
Yeah.
that need discussion.
It was a single committee motion for all
Right.
7. Yeah.
Okay. So,
Happy to lay out any of them or answer questions, but otherwise,
right. Otherwise, we'll call for a vote. So all in favor of these 7 items?
Aye.
Aye. Any opposed?
You know, I'm still trying, I think I had a question about one of these and I didn't write it down. If you'll just give me a brief second, I've got it in front of me.
No problem, Judge.
I'm sorry. No, okay, I'm sorry. Thank you.
Okay,
I vote in favor.
all right, and you're unanimous. Is that it? What else do we have?
So, Mr. Bunn and Judge Keller, that then gets us to, I think, through all the proposed legislation and brings us to a brief policy monitoring report from Mr. Lorenz. Mr. Lorenz.
Thank you. If you could, please turn to page 96. Since our June meeting, we've issued 4 policy monitoring reports. Those are for Bosque, Comanche, Brazoria, and Kinney counties. We've received responses from 2 counties, that's Taylor and Zavala counties, and we have 6 counties for which we've issued reports, but we're still waiting responses. As Wesley noted, the Policies and Standards Committee had passed a motion allowing staff to request additional data from Maverick and Zavala counties. In upcoming meeting notebooks, you'll see a summary of the number of council requests and the number of appointments and denials of council in those for those 2 counties. We also have a large number of counties for which we're about to issue reports, but the reports have to go through the Policies and Standards Committee. We're going to try to send those in groups so that the Policies and Standards Committee isn't overwhelmed. And I want to thank the committee members for all the work that they do with those reports. Just a couple more things. We do some drop-in reviews that are informal to small counties. Over last month, we made 3 drop-in reviews. Those were to Floyd, Garza, and Dickens counties. And we have upcoming reviews to Goliad, Kaufman, Clayburgh, Van Zandt, and Willacy counties. And if there are no further questions, that completes my report.
Okay, so that takes us to complaints.
Thank you. Good morning, board members. Our complaint summary is as follows. Between May 27th of 2020 and August 12th of 2022, both of those are 2022, that's my apologies. TIDC received 19 new complaints, which is about on par with how many complaints we received in that period of time. The 2 complaints remain open and are pending. 6 were forwarded to local officials, 13 complainants were sent stock referral letters, and 12 of those complaints were handwritten letters. The most common complaints are kind of the ones we typically see, which are appointed attorneys failing to communicate timely with their clients, as well as appointed attorneys not necessarily abiding by their clients' litigation decisions. The one complaint of note that I've put in the summary today was a complaint that alleges that their case was mishandled due to a prosecutor moonlighting as a law clerk for the judge who was handling that case. That defendant was actually represented by counsel on appeal, so we responded and notified the defendant that we cannot discuss issues outside of our scope, especially when the defendant is represented by counsel per the Texas Disciplinary Rules of Professional Conduct. That finishes my summary of complaints. I'm happy to answer any questions.
Okay. Otherwise, that's the end of policy and standards.
And Judge Keller, I think that brings us into family representation.
Okay, thank you.
And then we have Ms. Left-Pignon.
Hi, everybody. I'm kind of loud. I'm sure you can hear me. TIDC staff has completed a data report from the data that we've been collecting. So as some of y'all may remember, counties were required to report information last November for expenditures and judicial plans. We have a nice report that's all done. It has been given to Megan Lavoie. Technically, per statute, the Texas Judicial Council is responsible for distributing the report to the governor, lieutenant governor, and speaker of the House. So we're just waiting on that. The Texas Judicial Council does meet on September 30th, And we're hopeful that after that meeting, the report will be available for distribution and we can share that widely. So to give you just a little bit of a data highlight, can't give you all of the data, but we can give you a little bit. One of the requirements that the counties were supposed to share in their report was attorney fee compensation information. And unfortunately, we didn't have every county that did a report submit their info, but we have a pretty decent number, so we have a better understanding of how attorneys are being paid. We had 125 counties submit their information related to attorney compensation. And what we saw is probably what we already know. Rates are kind of all over the place, and the payment mechanisms are different depending on where you are. There is a table in the board book, it's on page 99 with that information. You'll see that most of the counties that did submit information do a general hourly rate, but we do have some counties that do combinations of flat fees or flat fees, cap rates, and hourly rates. We've got that on page 99 there for you to look at. And then to just further highlight compensation for attorneys who take these cases representing kids and parents, the report that hopefully will come out will have a lot of information about all of the different fee payment mechanisms. But right here, we've just got a little bit on page 100. So we have general hourly reported rates. You can see that on that table there. $70 to $75 per hour seems to be the most common one that we see. And then there's different payments, with 150 being the most that we received in reporting. And then we did have one county come in at $60 an hour, which is quite low, that they're paying their attorneys. We also have some information here for you to look at as far as payment for trials. And that's helpful information because termination trials are quite serious. And sometimes civil judges will call them the death penalty of civil cases when you're working in the civil courthouse, because essentially it can be the final end of a family for some people. So it's quite serious. And you can see here that the pay for trials, there's a range, and some of it is pretty low. When you look at flat fees for contested trials, we do have 2 counties reporting $275 to pay an attorney to represent, to do representation in these cases. So that's pretty low. I handle these cases for many years. I've sat in them for 2.5 weeks, 3 weeks sometimes. It's pretty hard stuff. And so that is definitely too low to pay an attorney. So moving on, for this coming year, we do have some data that will be coming in. So on November 1st, county auditors are going to be required to report expenditures. County auditors have to report yearly. Judges only have to report every 2 years. So we won't get judicial information until 2023. We have done a training already for county auditors. That was on April 28th about the upcoming reporting that's due. The reporting is going to be a little bit different this year. Last year, we only required auditors to report summary totals. And this year, we are asking that they report expenditures broken down into types of categories so that we get more information as far as how much is being spent on representing children, on representing different types of parents, and representing children and adults in appeals. We did do a survey for auditors and treasurers this summer to get some feedback. And some of the feedback we received was that collaboration could be helpful within their county. So we will be doing a training on September 20th for not just auditors, but auditors, judges, and attorneys who work on child protection cases, so that they all have information as far as what's being required and everyone's on the same page. And then we will have one other training on September 27th, which will be a Q&A just for auditors to help them out so that reporting goes smoothly. That's it, unless anyone has questions.
Thank you, Crystal. That's great.
Oh, I think Chair Collier has a question.
Thank you, Madam Judge Keller. I do want to ask some follow-up questions, because this is very alarming to me, and I'm sure for everybody else. But how many of those cases that pay the attorney $275, a flat fee for a contested case, actually go to trial? Like, do they actually go to trial? And
so that's the county's report. So that's just 2 counties in our. That's not for a case. We're not there yet where we know how much is being paid per case at this point. That is what a county reported they will pay their attorneys for 207 for a trial. I don't know if that county had any trials last year. They
Well,
may
that's the
have, they
point.
may not.
Well, that's the point. I mean, I probably wouldn't go to trial if that's getting paid $275 on a week
Well,
trial.
Yeah.
So that's something we really do need to dig into, because that's not ensuring the right to counsel. You're putting both people in a bad predicament in a place if you're getting paid, that small fee for all the work that you would need to do. So is this something that your a section of this CIDC would do, is to look into these rates and find out how their pool of attorneys looks like? Do they have a lot of people on their list? Is this their public defenders, or is this the manager assigned counsel? And do they have a lot of people that sign up for it? I just want to know, I know you're just collecting the data, but are we doing more than just accepting it? Are we trying to find a way to interpret it or understand and see how it's really impacting the delivery of services that we're obligated to do?
So I think Jeff and I will tag team those questions. I can answer the data questions. I could go back and look at the 2 counties that reported this and tell you how many lawyers they have on their list. We do have that information. If we wanted to cross-reference data points, that's certainly something that we do currently have. If we wanted to dig further into that. As far as what we can do, I'll let Jeff answer that a little more.
So Chair Collier, we have a pretty limited mandate when it comes to family representation and child protective services. Really, the mandate was from SB 560, and it actually doesn't mention TIDC. It's focused on the Texas Judicial Council and the Office of Court Administration. We are part of the Office of Court Administration, and TIDC is a standing committee of the Texas Judicial Council. And basically, we've been tasked by the Texas Judicial Council and by OCA with being the ones to collect this data. And I think that one of the easiest ways to think about it is, if you think about TIDC has multiple functions. We do policy monitoring, we do fiscal monitoring, we help plan new public defender offices, we receive complaints. All of those functions we really don't have when it comes to family representation right now. The very limited scope mandate that we have is much more comparable to our indigent defense expenditure reports and our collection of our indigent defense plans. So really, we can collect that data, again, is really kind of an arm of the Texas Judicial Council, and as an arm of the Office of Court Administration. But that's really where our mandate ends right now. We don't have the ability to do much research into this, or do policy monitoring or fiscal monitoring or funding. So our hands are a little bit tied in what we're able to do here.
So does the Texas Judicial Council, are they the ones that are charged or tasked, or does this fall under their jurisdiction to do that, what I'm asking about?
I think it's outside of their mandate as well. I think our mandate is basically kind of coterminous there, and it's really what just in the language you find in, and Chair, I'm happy to share the language that's in SB 560, but it's a pretty limited mandate right now. I think it is Ms. Left-Pignon mentioned, September 30th, the Texas Judicial Council will receive the report that that she's been working on, and determine what, if anything, to do from there.
Oh, okay. I was gonna say, there's a reason to collect the data. I don't think we just collect it and then just let it sit. I think that it should have a call of action, once you read it and receive it. So somebody's gonna take action on it. It's just not this board.
That's right. We don't really have the authority to do anything right now, but I think if it's okay, Judge Keller, I think Mr. Allison has a comment on this.
I just want to say thank you for taking on this task, and Chair Collier is correct. Remind us of how much the county pays of this cost to provide this counsel for our indigent parents and children, and how much the state pays. If I recall correctly, Jeff, it's county 100%, state 0.
Right.
I think Chair Collier
Yes, sir.
is right. We will be looking for action by the legislature next session for the state to step up and provide adequate funding so that we do provide proper counsel in these cases. Thank you.
Okay, anything else?
And Judge, we have just one more item on the agenda, which is an update from the improvement team, and I think that's it. Mr. Ehlers.
Yes, so if you go to page 102 of the board book, you'll see the improvement team's report for this quarter. Since y'all provided significant funding for a number of counties to establish public defender offices. At the last board meeting, we've been helping a number of counties establish their public defender offices. We have been getting a number of inquiries for new planning studies to establish new public defender offices and managed assigned counsel programs. Regarding our Future Indigent Defense Leaders program, Kathleen, with the help of Bill Cox, have been planning and doing logistics for the next FIDL training, which is going to be in San Antonio in October. Our investigator project is wrapping up, and we should have a report for y'all at the December board meeting. We've been helping counties, Nick Sawyer and Kristen Meeks in particular, improve their appointment systems through what we're calling our Indigent Defense Automated Appointment System. And we have a new publication, thanks to Olivia Lee, our Indigent Defense Coordinators Manual. And all of y'all should have gotten a link to that, but I can send you a copy if you need it. That's it. Thanks.
Okay, thank you, Scott. Jeff, I think that's the end of our agenda.
Yes, Judge, that's correct.
Okay, before we close, I just want to say thanks to Nick Sawyer, and on behalf of the commission, wish you well going forward. And is there a motion to adjourn the meeting?
So moved.
Second?
Judge, we have a motion from Mr. Munn and a second from Judge Evans.
Okay, all in favor?
Aye.
We are adjourned. Thank you all very much. Have a great weekend.
Thank you. Thanks for your patience,
Bye,
everybody.
everybody. Thank you.
Bye.
Bye, all. Thanks.
Thank you. Jim, we've got a bag for you.